the plaintiff, as the buyer, should contact the HOA immediately to ascertain the exact amount of future dues or assessments. That was right in there. It's section 9 of the title disclosures on Exhibit D8. Reading that, it put him on notice, and he should have done exactly what it said there. And if that's not enough, plaintiff introduces or attaches a summary judgment evidence, Exhibit 28, which is an email from the HOA, the condo HOA, to plaintiff about the balcony project, and that is Plaintiff Exhibit 028. It discusses the bids, the peer review to be done, and estimates that repair costs of between $2 million and $10 million, and even has a link that states you could see what portion of your unit would be responsible for here. And it appears to be a live link that Mr. Bass could have clicked on to find out how much he owed. That was an email dated September 2nd, 2022. So even if the discovery rule gets past the closing, it certainly can't get past that September 2nd, 2022 email, which clearly gives rise to the fact, or presents the facts, that Mr. Bass, if he's acting diligently, would be on notice of the claim. And then just last, Your Honor, because I know I'm probably running out of time, I just want to point out we did file part of our motion is seeking attorney's fees. Attorney's fees are recoverable under the contract itself at paragraph 17, even as to the escrow agent. And that is supported by Exhibit D9. And my apologies to the court, I accidentally duplicated that exhibit. So D10 is actually an exact copy of D9. That was just a mistake. I also included today a declaration, which was not part of the initial filing, which was done in April, which is my declaration that proves up an additional $11,317 in attorney's fees from April 13th, which was just prior to when we filed the motion, and through yesterday. And
you filed that with the clerk's office, you said yesterday or today?
I actually just attached it as an exhibit today. That's okay. I put it in the box, Your Honor. That's all I did right now. Okay. And that's it, Your Honor. I mean, I think Mr. Marconi did a great job describing and explaining the no evidence points, which we agree with. And as I mentioned, it applies even more so to my clients. And our briefing is, I believe, does a good job of explaining that, as well as some of our additional traditional summary judgment positions. And unless the court has any questions, I will go ahead and stop talking. Thank you.
All right, Mr. Bass, you have filed 2 responses, obviously one to each of these motions. Why don't you, for purposes of clarity, let's go ahead and take your responses to Mr. Stallone first for the escrow agent and the title company. Let's do that one first, and then I'll give you some time to address the no evidence summary judgment motion that Mr. Marconi has filed.
Yes, Your Honor. I had prepared my paperwork for Marconi first, but
that's all right. If you prefer to do it in reverse, go for it. I just need to be clear on which one you're responding to.
Sure. First, I'm going to start with Marconi. And Your Honor, I'm sorry for arriving late. I was 15 minutes earlier from the other meeting, but that was my mistake. So I will start with the introduction for that case, and then I will go down each claim to show the evidence for each claim. I begin with the standard because the standard dictates this motion. The defendants filed a no evidence motion under Rule 166A. It is a narrow instrument. It does not call for weighing evidence, judging credibility, or choosing among inferences. It asks one question only, whether I have produced more than a scintilla on each element of the defendant challenge. If I have, the motion fails as a matter of law under King Ranch versus Chapman. Start with the relationship because it defines the duty in this case, and it arose by operation of law. Marconi was my agent. A broker who represents a buyer becomes that buyer's fiduciary.
Clear up just one thing. Just let's start off with that. Mr. Marconi is the attorney in the case. He was not your agent. He's the attorney for who you're talking about. Isn't that right? Manchala or something like that is who you really mean?
Yes, sorry, Manchala. Yes.
Okay. I just wanted to clarify that. It made Mr. Marconi's head pop up when you claimed that he was your agent. So I just wanted to clear it on the record. Okay.
I'm a man of many talents, Your Honor.
Thank you, Your Honor. English is my second language, so I'm doing the best I can. Sorry. A buyer becomes the buyer's fiduciary the moment he undertakes the representation, and no writing contract is required under section 1101.557 of the Occupants Code. And a fiduciary is not held to the standard of a stranger dealing at arm's length. He is held to the highest duty the law imposes. The state's own rules say it's in its own words, the broker owes that client the highest fiduciary obligation, which includes conveying all known information, the pleading the client's interests above his own. And it's under Title 22, Section 535.156 and 535.2 of the Administrative Code. That duty runs one direction only, from the fiduciary to the principal, from him to me. Manchala admitted in his deposition that he pre-filled the certificate recipient box, which he called himself a misstatement made to win the offer. He admitted he read the spelling disclaimer April 22 and chose not to say anything. He admitted he never advised me of any statutory right to terminate. Those are his words under oath. A party sworn admissions can defeat a motion standing alone. And because he was my fiduciary, the law did not require me to distrust him or investigate behind his representations. The law entitles a principal to rely on his fiduciary to make him second guess that fiduciary will dissolve the very trust the duty protects. His intent, moreover, needed not to prove directly. It may be inferred from the same admissions and from his commissions on the sale under Spoljak versus Percival Tours. That is the posture in which the defendants asked the court to take this case from the jury, and they cannot. A movement does not win judgment as a matter of law against the testimony he gave himself under oath, and an agent cannot escape his torts by pointing at other people. So that's my introduction. I will start with the count number 2, which is the number 1 listed item in Marconi's motion. He challenged item number 2. Okay. Item number 2 of breach of fiduciary duty, which is the breach. Your Honor, the breach is proven by Mr. Manchala's own sworn words. He filled the C1 himself. He called it, in his own words, a misstatement. Manchala deposition, page 101, line 24, through page 112, line 2, page 113, line 1 through 4, and page 110, lines 4 to 6. He admitted that by April 13, he knew the certificate I was holding was out of date and never told me anything. That is at page 135, lines 3 to 5. He read the warnings about the balcony conditions, the ongoing engineering study, and the upcoming assessment on April 22, the day it arrived. and he said nothing through the closing on May 6th. That is in page 142, lines 11 through 20. His duty to tell me what he knew was not optional. It was required by law. Title 22 of the Texas Administrative Code, Section 535.156. He had even watched earlier clients walk away from deals from exact reasons at page 152, line 12 to 23, and he stayed silent anyway. Any of these admissions by themselves is more than a scintilla for the challenge element. That was the only element, Your Honor, that was challenged for a breach of fiduciary duty, which is count 2. I will go to the next one, count 11, negligent misrepresentation. I will first say the elements that they challenge. Defendants supply false information for the guidance of others. That's element number 2 of negligence misrepresentation, authority Fraser versus Burnell. And I will talk about that element first. There are 3 false statements, the April 3, and 2 of that landed the same day. First, Mr. Manchala deposition, he wrote that there was nothing really glaring about a package that he held a certificate more than a year old when he never read it. That is in page 97, line 25 through page 98, line 7. And page 69, line 2 through 5. Second, the same offer he sent through the purchase contract P13, he pre-selected C1 before sending it to Mr. Bass, which he admitted was a misstatement in that he pre-filled such checkbox. That's in line, that is in page 111, line 24 through page 112, page line 2. And page 113, line 1 through 4. Speaking positively about a document you never read is a reckless false statement under JP Morgan Chase versus Okra at page 653. The April 13 an amendment he represented as a fix that he did by his own admission, quote, did not spell out any effect in the C1 and fix nothing. That's in page 130, line 22 through 24. And in page 129, line 13 through 17. Now I'm gonna go through element number 3, which is defendants did not exercise reasonable care or competence in obtaining or communicating it. A careful broker does not fill a legal compliant box without checking it first. Does not swear a package is fine when he holds a certificate he never read. Does not present an amendment when he does not even understand its effects. In Manchala's deposition, admitted he did not understand the amendment at the time and that his own theory about it came from a lawyer afterwards. That's in page 138, line 6 through 13, and page 133, lines 7 through 12. The standard for a broker is in 22 of the Texas Administrative Code, section 535.156. And he knew these warnings blocked loan approval. That is in page 152, line 12 through 15. The other element challenged, the last one for negligence misrepresentation, was element 4, justifiable reliance, pecuniary loss. The law entitled me to trust my own agent. That's in section 101, 0.557 of the Texas Occupations Code. And I swore to the reliance twice in my own deposition. I quote, "I relied on my licensed professionals to flag anything that was important." That's in page 84, line 4 through 6. And again, at page 66, lines 10 through 13. The loss is documented in the closing disclosure. Part of the capital that was put in the property that amounts more than close to $200,000 in cash. And the short sale documents, which it's one of the main injuries of the case. Whether my reliance was justified is a normal question of fact under JP Morgan Chase versus Okra Assets at page 654. Before I start the next counts, Judge, do you have any questions for me?
No, sir, that's not how this works. You're just going to provide me and I'm going to rely on your brief. So you just go ahead and move to your next matter.
Thank you, Your Honor. I will start with count number 4, negligence.
Now you switched over to the second set of defendants. Is that right, Mr. Stallone's clients?
No, I'm still in no, Your Honor, I'm still in Marconi's.
Okay, well, understand you've got about 15 minutes per case, so your time's about up on Mr. Marconi's. That's why I'm asking.
I will go as fast as possible just to cover the entire challenge elements.
Well, you have, I'll give you 5 more minutes on this one, then we're going to switch.
Thank you, Your Honor. Negligence, the challenge breach and proximate cause, which is the authority Rodriguez Escobar. Breach is the same admitted conduct, now measured against the standard of reasonable broker. Mr. Manchala deposition, he failed C1, and that's the same citations that I mentioned earlier. Element 3, proximate cause. Proximate cause means a direct cause for his silence, meaning if he had told me anything of this, I would not have closed. This is my declaration in paragraph 23, and it's backed up in my own deposition at page 90 and 91. The law allows more than one cause until Leeser Sagler versus Paris. And this loss was specific to my unit, not the whole market. HOA own warrantability email. Exhibit 28, the fact that the 99% of lenders wouldn't lend. The email P34, 3 failed normal sales and conventional sales, 2023, 2024, and 2025. That's P33, 41, and P42. A fraud by non-disclosure, which is the challenge elements 1 and 4, which are defendant's delivery failed to disclose a material fact, which we already talked about, Your Honor, the material facts that they withhold, but just to reiterate, it's he saw the April 22 certificate, he read the disclosure for the spalling balconies and the damage, and he did not say anything about that to his client. So that's a deliberate failure to disclose. Duty to disclose, his duty to came from the occupancy code that we mentioned earlier and the administrative code. In Mr. Manchala's deposition, his own words, quota, said, "Not my job." In page 135, line 21 to 23, cannot shrink a duty the law imposes on him. And number 3 is, I think, an important one. It's ignorance, no equal opportunity to discover. Comparative compare a layperson to a 17-year-old broker who controls the flow of information. In Mr. Manchala's deposition, he handed me a pre-filled contract in a 15-minute window to be able to sign. Yet he claims I should have hired an attorney to look over the documentation. He set a deadline on the contract for just a few minutes on the contract for me to sign. Knowing that the document exists is not the same as knowing a hidden defects. This goes for the April 22 email. That's Bernstein versus Thomas. And intent to induce, his purpose in his own words, quota, win the offer. That's Mr. Manchala's deposition at page 113. Intent is the jury's to decide, and it can be conducted from his conduct. Splojak versus Receivable Tours, count 9, statutory fraud. He challenges element 1, a false representation of material fact. That's 3DC1 of the purchase contract. Also the resale certificate he sent that was about a year old, stating that it was nothing glaring there. So those are the main ones. And they didn't challenge any other element for that one. And the last one is the breach of contract. Valid contract. A buyer agency was formed by how we acted. He filled in and sent me the offer in April 3, negotiated the April 13 amendment, guided me through May 6 close. He was present in the May 6 closing, and I did my part. I signed the contract he indicated. I did the performance he indicated. I got the inspector he indicated. I didn't got represented by any other broker in the transaction. So I fulfilled the terms. Also, the implied agency, it's under law, like the broker services disclosure form, the IBS, exhibit P05. It's not required to be signed. It just shows the minimum duties the broker has with his client, and also his responsibilities for the client, towards the client. I think that's all for all his challenge element, unless Mr. Marconi has.
No, that's not how it works. All right, now you can switch gears and you can talk about the motion for summary judgment that was brought with regard to Mr. Manchala and with regard to Capstone and Ms. Zapata.
Just one moment, Your Honor. I'm going to start with the introduction. I think it's just an overview of, before I start. The defendants move on 2 grounds and have carried neither. On the traditional ground, the burden is theirs to show no genuine issue of material fact, every inference drawn in my favor, and on the no evidence ground, they prevail only if I produce less than a scintilla on a challenge element. That's standard. The Supreme court fixed in King Ranch versus Chapman, but the court need parse this motion element by element because all of it rests in one premise, and the premise is wrong on as a matter of law. The premise is that the neutral escrow agent owes me new duty. It's backwards. An escrow agent is a fiduciary relationship. A person the law places in a position of trust between parties and holds the high standard it knows. Full disclosure, undivided loyalty, and personal care. The Texas Supreme Court held that in City of Forward versus Piper 1969 Supreme Court that is binding, and it's been the law for over 50 years. The neutrality they talk about the defendant's evoke is the source of the duty, not the absence from it. The duty does not rest on one case alone. It rises from the escrow relationship itself. The Capstone Own Act of ordering and paying the certificate for the title licensing statute that governs Mrs. Zapata, the court may deny the motion on any of them, nor the defendants is interested on the transactions. And their own closing disclosure shows Capstone earned $4,598 on this closing and advanced $384 with 80 cents of his own money for the very certificate in issue. And for this fiduciary reliance follows, the law does not ask a fiduciary beneficiary to audit the fiduciary. That will dissolve the trust the relationship exists to protect. Ms. Zapata copied the fees from the certificate to the penny onto the closing disclosure she handled, treated the structural warnings printed right beside and vertically from the fees that she copied as no part of her job, and told me it was okay to proceed while the certificate was missing from the closing table. Whether I relied is under JP Morgan Chase versus Okra Assets, a jury question and sworn testimony that I would not have closed had the defendants had disclosed raises it. They will hold up the title company disclosures from a waiver. It's no waiver. The disclaimer of reliance bars a fraud claim only when it's clear, negotiated, and struck at arm's length between sophisticated parties with counsel. Ms. Zapata testified the form was never negotiated. Ms. Zapata testified that it was never shared in advance and signed within minutes. Under Italian Cowboy versus Prudential, the defendant's own authority, Slumberger versus Swanson, that boilerplate bars nothing in this case. Finally, Mrs. Zapata does not escape her own the conduct by pointing to her employer. An agent is personally liable for her own tortious acts and even within the scope of employment, which is held in Miller versus Kaiser and reaffirmed in 2024 in Keys versus Weller. That is the introduction for that one. Mr. Stallone did file a traditional motion, but I will continue. I will, Your Honor, I will go down the line again, if that's okay. But I don't know if we have enough time.
Well, you've got about 8 minutes, so pick and choose.
Okay.
You want to draw our attention to the most important aspects of your response. It's what you need to do.
I will go with the boiler disclaimer that they say that it's not that I sign a closing that removes their duties. Their disclaimer does not bar anything, Your Honor. It helps to walk the court through where the rule comes from, and it starts from Slungberger versus Morrison, 1997. It's affirmed in
Is this
court.
in your brief?
Yes, everything is in my
Okay.
brief.
So you've got it in the brief, so draw our attention to it and then get your next point. Tell us where it is in the brief and what we need to see.
Yes, Your Honor.
You don't need to read us the brief, is what I'm getting at.
I'm just gonna go down the biggest points. Neutral party is in section 4.1. Non-negotiated, no guidance. It's also in 4.1, section 4.1. No duty to represent the closing, the certificate. It's also in 4.1. Accepted the funds on a still certificate that was in April 7. Also in 4.1. So I answered every single defense. I'm just gonna go down the defenses that are in 4.1 is voluntarily undertaking. 4.2 is the fact questions, like if the email fulfilled the duty, that the plaintiff had the certificate, and also the half-truth that Zapata did by copying just portion of the certificate and presenting it in the closing. They state that Zapata didn't have no responsibility because she didn't read the disclaimers in the resale certificate and thus has no responsibility. However, basically an HR manual cannot override Supreme Court authority, Your Honor. That is in section 4.2. The boiler disclaimer defenses are in 4.3. And the
Okay, and what page is that? What page number is that in your response? You got a 795 page response. So what page are you talking about when you jump over and say 4 point this or that? Do you know what the number is in that, where I can go to it?
Yes, Your Honor. One moment. So for yes, I have also a table of contents to make it easy because I know it's a lot of information. In the second page, I have the table of contents and the for 4.1, it's in page 75, 4.2 is in 82, and 4.4 is in 89, page 89. And 4.4 is in 93. And in section 5, I go down each challenged element in the petition, and that's in page 96. That's where the section 5 is all the challenge elements, all the challenge claims with the elements challenged. Section 6 is in 111, that's the limitation defense and adverse inferences. That's where the limitation of statutes they're talking about. And also I volunteer some disputed facts questions in section 7, which are in 117. And I object to certain affidavit statements that Zapata did. That's in section 8, 180, page 180. 118. And I think that's the summary of the entire reply, other than and I just want to say the factual background is in section 3 in both motions. So I tried to do it as easy as possible. So the backbone for the factual background is in the petition, in the Second Amendment petition, which is the current petition in the case. And in both Marconi's and Mr. Stallone's clients, MSJ replies that I submitted have the executed summary in Section 1, Section 2 standard of review, and Section 3 the factual background. So they kind of follow the same architectural way, and I included also a table of contents for it to be easier for anyone reading it.
Okay. Anything else?
Yes, I just want to clear up something that they might be confusing and took me a little bit of time to understand. When they say third party, neutral third party, initially they were talking about the structural, just because they're not a buyer or seller structurally, doesn't mean they don't owe no duties. In this case, third party, it's a relationship based. They owe duties to not only the seller, the buyer, and also the loan company. The citation that they use, the home loan versus Texas America, is the case about the loan company suing the escrow agent for non-disclosure, which they won in the appellate court. The closing process they're talking about, it does not restrain it to just the closing day. The closing process started in April 7 when they undertook the earnest money funds, and it started there April 22 when the email was sent us around the middle portion of the closing process, and the end of the closing process is May 6 of 2022. So
You understand they are not denying that there is a obligation as an escrow to take the money, maintain the money, see to it that it gets distributed correctly, and that the documentation necessary for the title policy and the such is filled out and done. Their argument is they're not your agent, they're not your lawyer, they're not there to explain stuff to you, is their argument. Okay? That's not their job. That's yours. And they claim, of course, in their paperwork that you received, when we're talking about these balconies, that you received that April 22nd report at the same time, basically, that the other one of the named defendants did, the realtor. And but when we're talking about the escrow, they have a duty, obviously, not to steal the money, not to falsify documents, those kinds of things. But they don't, their contention is they don't owe an obligation beyond that as a fiduciary to explain documentation, to do that in terms of accepting a responsibility to act as your attorney in fact or in any agency role. You understand that's what they're contending.
and I just want to respond really quick on that.
I want you to.
Yes. So the possession does not mean disclosure. In this case, the Texas Supreme Court has decided this in Smith versus National Resort Communities in 1979. And the buyers were, in that case, were handed a 28-page declaration at closing. And the court said that a careful reading of the entire 28 pages would not have recently alerted them to the easement on their lot. When they send the resale certificate, they send it in a bundle of 554 pages, which they didn't highlight that it was updated, no material information from it, even though they order it, put it in the bundle and send it. The only new document in the email was the resale certificate. All the other documents they bundle it with was predating the transaction. And still they bundle them all together and send it to me and call it disclosure based on the law. I'm not trying to have the title agents, and by the way, I renamed them to be escrow agent defendants because the title company has multiple hats. They can have, I'm not disputing the title of the property. I'm disputing the escrow portion of what they did. I'm not asking them to be my lawyer. I'm asking them to fulfill their duties based on the law in the city of Fort Worth versus Piper 1969, which is full disclosure of material information. Yes, glancing at the paper that they ordered, put it in a bundle of 554 pages and calling it disclosure cannot be, does not bar my claims. If that was the case, anyone would have done that and call it disclosure and get away with any kind of fraud or misrepresentation ever.
So when you're provided a disclosure, you don't believe it is your obligation to read it and to pay attention to what's in there? Is that kind of, it sounds like what you're telling me.
I did, there was, this goes back to Marconi. When we would sign the contract in April 3, he fulfilled the C1. The C1 is very important in this case because it states that I had received the current statutory compliant.
Yeah, but we're talking about the escrow agent at closing. So in the packet you received in advance, 500 and some odd pages you talked about. When you receive that, whose obligation is it to read that is my query. You believe it is theirs to go down and explain every bit of that to you?
No, Your Honor. The pages that they sent was not the closing packet. It was just for your records sent to multiple people. I'm not asking them to read every single line. I'm just asking them to tell me or flag important information that's detrimental. The special assessment crystallized to $17 million in total. And something that important cannot just be waived. When they got the resale certificate, and I can exhibit, they took the fees right next to all the disclaimers of the balcony. And then put it back in the stack and send it. They didn't put it in the closing packet, and they represented figures of the condo, which was half truth because the assessment was going to be allocated to the HOA members and owners, which encompasses the owners. And it caused a domino effect of damages. Yes, because it's analogous to saying, for instance, like an Amazon driver. You have an Amazon driver, they just have to scan the packet. That's their duty, that's their job. But if they ran over someone, even if they don't see the person, that doesn't mean they have no duty, no liability, just because they didn't see the person and their job solely is to deliver the package. When they ordered the certificate, they had to do it with duty of care. That's loan 552. They put in a packet of 552 pages. They didn't do duty of care. They didn't fulfill a city of Fort Worth, which it's a Supreme Court binding law, and they cannot supersede their duties just by an HR manual, Your Honor.
Okay. All right. That'll conclude our time for all sides. We're going to, the staff attorney and I are going to spend some time and we'll go over it. We've already spent a considerable amount of time reviewing it in advance, but we'll do some follow through based on your arguments and go back and review some things with it. Let me just make sure we've got everything. Mr. Marconi, everything you have, you've got a filed either in box or it's attached to your motion. Is that correct?
Well, mine is a no evidence motion, so there are no exhibits to my motion for summary judgment. I do have an order filed prior to.
All right, and then Mr. Stallone, you've got everything in front of us that we need to look at?
Yes, Your Honor. Everything's in the box.
Okay. All right, and then Mr. Bass as well, you have everything filed as you intended?
Yes, Your Honor. Every exhibit is there.
Okay, thank you all for your time. We'll conclude the hearing. You're excused to leave.
Thank you, Your Honor.
Thank